Ms. Malachi, good morning. Thank you very much for your time this morning. Just to clarify one thing, what are you asking the court to do? Just if you could just tell us very briefly, what are you asking the court to do?
Morning, Dan, and to the viewers. We've got a two-part application. Firstly, we're seeking a suspension of the implementation of the remedial actions she has directed as regards various state institutions. So you're talking the Speaker, which is imminent in 14 days of a report, then the President in 30 days, and then the Minister of State Security, then the National Director of Public Prosecutions, and so forth. So that's part A of the application. That's brought on an urgent basis to be heard on the 23rd of July. Secondly, we then seek a review and setting aside of a report on a variety of grounds.
Okay, but the whole report you want to be set aside?
Yes.
Based on a number of grounds?
Yeah.
One of the grounds I've sort of heard, and I in my introduction, is that she's misunderstanding the intelligence laws. How so?
Well, let's start with the Constitution. She relies on Section 209 of the Constitution, which says that only the President may establish an intelligence service. Now, the unit that was established at Sars at the time, in 2007, is not an intelligence service. It's a high-risk investigation unit intended to target taxpayers involved in illicit trade, involved in organized crime, and at the high end of people who should be paying taxes and that are avoiding it. That's what the unit was intended to do.
And it is the argument of Mr. Gordhan that SARS is within its rights to set up such a unit?
Well, it is within its legislative framework to do so because it must have enforcement capacity. And that capacity includes the ability to be able to gather information and make sure that those who think they're intelligent in avoiding tax can be caught out and be brought to book.
So what has become urgent about it? I'm just trying to understand as well, because this is an urgent interdict. It's going to be here, you said, on the 23rd of July. What has made it to be an urgent application? Well,
the Speaker of Parliament is directed in remedial action by the Public Protector within 14 days to convene a hearing by the Ethics Committee to look into Minister Pravin Gordhan's declarations at Parliament. So that's 14 days. So if no action is taken in 14 days, then of course, that
parliamentary process would happen.
Would have to happen.
So your client wants, before that can happen, for everything to be stopped.
Yes.
Basically.
Pending the outcome of a proper ventilation of a review application.
And where is that judicial review application at currently?
Well, it is Part B of the same application, the interdict application. So in Part B, it is where we say that report must be reviewed and set aside. So what the court looks at is it says, do I stay the position as it is, pending a determination by a court on whether the report should be reviewed and set aside.
Okay. Now, from what one has seen and what is hearing, the Public Protector seems convinced that she is correct. When you do such an urgent interdict and application, what does a court do? Does a court then discuss the merits of the case to make a decision, a ruling on whether or not you can interdict and suspend the report?
Well, no. The test is fairly simple. What the court does is it looks at the prospects of success of the review application. So in other words, do you have a fair chance at convincing a court that the report must be set aside? And it assesses that, not the merits itself of the review, and then it says, well, pending a court looking in full at the review application, I think you've got a fair chance, and therefore I suspend the effect of the remedial action.
Yeah, the whole constitutionality of this thing is comes out very strongly in this, because there's I saw the press statement. There's a question that you are making on behalf of your client about the conduct of Busisiwe Mkhwebane as Public Protector, and that it's feeding into the history of incompetence, of unlawful and unconstitutionality. That's very strong.
Well, it is strong in the sense that you must have regard to court cases, and we've stayed away from the realm of speculation. So we say, you look at the ABSA case, you look at the Reserve Bank case, you look at the Estina Diary case, you look at Minister Nkwinti's case, and the recent one now brought, not determined, by the Financial Services Conduct Authority. They've got two elements to it. The first one is all of those cases and the decisions of the court says there hasn't been a proper investigation, firstly. And secondly, there's been a misconstruction of the law, so misapplication of the law. And we say, given those circumstances, and you look at our own case, we complain about the same things. We say facts not properly investigated and law not properly considered, got it wrong in law, got it wrong in fact, and therefore that impacts on whether the report can stand scrutiny by a court.
Yeah. And another request you are making to court in your urgent application, one would understand it, that you want her to be, that the cost should be paid. But why do you want in your application for the court, her to pay the cost personally and on a punitive scale?
Well, the determination of whether costs must be borne by a public official or not is simple. In other words, the level of your discharge of duties measured against what was expected is what would be applied. So, put differently, if you don't discharge your duties to a level where it can be said to be reckless, as Minister has suggested in this case, then why must the public funds be disbursed towards your reckless conduct? And we're pegging this particular investigation at that level, and we're using the prior cases from which we thought she would have learned a lesson as a basis for saying why should the public purse then be burdened and not the incumbent of the office.
Okay, so we're going to have to wait for the outcome when the case is heard on the 23rd of July. Thank you very much, Ms. Malachi.
Thank you.